Good afternoon. Today is Tuesday, September 15th, and I want to put up a brief review or summary of what I think is important from Chapter 3. Those of you that find some of this stuff in the early chapters to be, I don't know, esoteric or not really related to what you thought business law would be about, and the heart and soul of business law is contracts and contractual obligations. But you need to know the backdrop a little bit and some other aspects of legal issues that develop for people involved in business, especially transactional business of some kind. Chapter 1, again, was what law is and the kind of the permeations of how we structure law in our society and the sources of law. Chapter 2 are the courts and the judicial system. And Chapter 3 really does get into some substantive law. Some of you will find this interesting, but a lot of you are going to say, I can't wait to get to Chapter 5. I get that. But Chapter 3 starts off with torts, business torts. I don't know why they call it business torts. Torts are torts, but they're talking about the kind that are specifically likely to be incurred for businesses. What is a tort? It's a private wrong. It's different than crimes. Torts are generally civil in nature. Sometimes they overlap. If somebody punches me in the face and I chip my tooth as a result of that punch, that's both a criminal act, an assault and battery, but it's also the civil tort of an assault and battery. Just like killing somebody is a murder, but it's also wrongful death. Both have different elements, but they fundamentally are geared towards the same set of elements in terms of conduct. What we're going to talk about in Chapter 3, most of them aren't crimes, but some are. Those are the intentional torts, which I'm going to go over real brief. An intentional tort means the defendant wanted to bring about the consequences of their act. It's not accidental in nature. Why we don't talk about those too much is most of the time they are also crimes, and therefore the criminal justice system often brings us justice in terms of a restitution. If we lost any money, if I had to have dental work done, the defendant would be charged, and through that process maybe we can develop a resolution of the case where some restitution be paid for my dental bills. That will say, for example, a criminal case never came. Could I sue the defendant civilly and seek damages? That's what we call damages, money for maybe my pain and suffering, but more importantly, get my tooth fixed at the dentist. Yeah, you can. But the reason why we don't do it that often is who are engaging in intentional torts? Intentional torts are things as false imprisonment, type of form of really almost kidnapping, libel and slander. That's probably the biggest intentional tort that might come across in business. That's telling a knowing factual lie about either a person, and it's called commercial disparagement if it's about a product, but it has to be a factual, not an opinion. Oh, the product is awful. It's very shoddily made. That's an opinion. You can't sue over that. But if I said something factual, like the Tesla Model 3 can only get 50 miles after a full 24-hour charge on a 220 circuit, if that turns out to be completely false, and it somehow hurts Tesla reputation because maybe I'm a big shot. I don't know, I'm out there and everyone knows who I am or something. I'm some big guru in the media. And as a result of my statement, Tesla sales for Model 3 fall off because they're deemed to be not worthy of the money they're getting. They could sue me for what we call commercial libel or a material false statement of material fact about a good, and it causes economic harm and interferes with their economic expectation. Those are intentional torts. Those are the kind of ones that are important for you. The book is really straightforward. I'm just trying to put this in here as a video to kind of augment some of it. But the thing about intentional torts that's kind of interesting is usually insurance doesn't cover it. So most people that are engaged in classic intentional torts, not those dealing with commercial transactions like libel and slander of a product or a service, but things like assault and batteries, things of that nature, won't be covered by insurance. And people that are engaging in those kinds of behaviors usually don't have a great deal of wealth. So what are you suing for? And the other thing, too, is how have you been damaged? If someone punches me in the face, I get red for 24 hours, but I don't really have any dental problems. I don't get TMJ. I don't really even get any bruising. I don't miss any time from work. Have I been wronged civilly? Yes, I have. I've been also wronged criminally, but that's the government's decision to take a criminal complaint against that individual. So I sue them. I have to establish damages. What are my damages? Humiliation, fear, anxiety. Those kinds of things don't go so well in court. You really need objective, measurable damages to succeed. I'm not saying you can't sue for those other causes. They just generally don't work. Intentional torts aren't going to be hopefully that big a deal for you in your business transactional life if you're entering into the business world. And most of you are business majors. But torts, private wrongs that we can sue over, and you need to know the elements of intentional tort. It's an act by the defendant. It's going to be a voluntary act. So if I had a seizure, I had epilepsy and a seizure, and I start flailing near you and I strike you, that can't be an assault and battery because I didn't have the requisite intent to make harmful contact with you. So it has to be a voluntary, intentional act of the defendant. And it has to be causation. It causes damage to you. I know this gets a little weird, but we'll talk about it in the negligence realm. But sometimes an act will have consequences that weren't foreseeable, or they're not necessarily the result of my activity. So say I intentionally go to hit you, and next thing you know, you tell me you developed a serious loss of vision, and you believe it's because I struck you in the eye, but my medical doctor looks at you, and it turns out your eye condition is related to a degenerative molecular, I can't say the word, but basically your eye is deteriorating naturally through some glaucoma or some other natural disease. It has nothing to do with me striking you, just coincidental at the timing where it started to develop. And therefore, you don't have what's called proximate cause. I did not cause your eye injury. Most of the time, it's but-for cause. It's obvious. You punch me, my glasses are broken, I need a new $350 pair of glasses. It's obvious. But sometimes things happen where you think they're related to one person's behavior or conduct or companies, but it might not really be the reason for the harm you seem to be suffering at that moment. That's called proximate cause. But for the fact that they did that, this wouldn't have happened. It's obvious. You rammed into my car, my bumper fell off. We know that's what happened. But what if my bumper I knew was already kind of hanging by a thread, and I stuck some duct tape on there hoping to pass mass inspection. You tapped me in the rear of my bumper very, very lightly at the stop sign because you were just easing up the brake a little bit too quick, and the bumper falls out. Is that really the proximate cause? Your negligence or your tortious behavior caused that injury? Well, you can say, well, it caused the duct tape to lose its adhesion to the back of the frame of the car, but it's really not the but-for causation of an event. So intentional torts, don't get too worried about it. I think I asked one little simple test questions on that first test. Some of you are looking for the test. Relax. It doesn't come up until near the due date of, a couple days before the due date of all chapters from that module 1 through 4. So I think the due date's Sunday. I'll probably put this up. I might even put it up today or tomorrow. Don't take it early. Make sure you read the material and you study for it. I mean, you can take it early, but why not study as much as you can before you do take it? Negligence torts. This one you have to worry about. If you're a business owner or if you're just an everyday person, you should know about these basic conceptions. Negligence is the biggest area of law. It's usually not found in a statute, not usually directly in a statute. The concepts of negligence come from the common law, from appellate cases and beyond. They created this principle that if one person's carelessness, that's what negligence means, failing to act or to act appropriately based upon the conditions that are currently existing. Boy, that was terrible. Terrible definition. Disregard that. It's failure to act as a reasonable, prudent person would in the circumstance. We all kind of know it intuitively. Hey, you're acting inappropriately. That's dangerous what you're doing. It doesn't have to be dangerous. It just has to be lacking due care, what a reasonable person would do under the circumstance. Being cautious not to say reasonable man, because that's how I was taught in law school, very sexist language. It's the reasonable person standard. It's not the perfect person. We can all look back in hindsight and say, geez, I could have done an even better job in the way which I drove. I could have went under the speed limit. I could have had a car driving in front of me that I hired to look out for potential obstacles. I could have had a siren on my car to warn people of my driving in the area. We all can do something to a better level. It's what a reasonable person would do under the conditions and the circumstances. We're not looking for perfection here. And that's the problem with negligence torts is sometimes we argue, well, that's unreasonable. Because, that's reasonable under the circumstance. An accident happened, but it wasn't because of the failure to act reasonable. It was reasonable under the circumstance. And you can't look back and say, well, the accident wouldn't happen but for that. Accidents sometimes happen without fault, meaning that the other party wasn't acting in any way foolish. That's what negligence is, foolishness, right? So for a negligence torts, and I do ask a couple test questions on it because it's kind of classic. Some of you are legal studies majors, and you'll be doing a lot of torts. You can't avoid it on some level or the other because it's a lucrative area of practice for attorneys. Either on the defense side, you're defending someone who's being sued for a tort, Or you're on the plaintiff side. You're suing someone that's lost either property or they've been physically injured because of somebody else's alleged carelessness. You're going to sue. The elements are always the same. We all have a duty to act reasonably in the circumstance. What that is purely contextual. It all depends on what the circumstances are. I used to, when I taught in this class, in a brick and mortar class up in the mountain, I'd say, is it reasonable to throw a javelin towards a big group of people sitting in a big seating area in a bleacher near a basketball court? Of course not. We know there's a very strong likelihood someone might be injured. You breached your duty of care. But what if there's an open field in a meadow and I can see for miles and I see nobody in any visible area, and I throw it in a direction where I see no visible people? I didn't realize, but under that pile of leaves, there was a young person being, I don't know, a prankster, and they were hiding under the leaves, hoping to scare their friend when they walked through later, or expected to walk through later. Therefore, I wasn't necessarily negligent, even though an injury occurred, because of the foreseeability. And that's the test. How are we supposed to behave in any given context? The way we drive, the way we walk. I think about the way, I remember walking down to law school and I fell down a flight of stairs and all my books and papers went flying. And not that I'm that agile, but the way I fell, I kind of, after I did a couple of somersaults, I actually kind of landed on my feet almost like a gymnast. And instead of looking awkward and turning around and picking up all my papers and books that went all over the place, I just kept walking like it was kind of intentional. That's sort of negligence hanging in the wind. No one was injured. But think about it. Do you have a duty to walk differently if you're in a very crowded hallway in the way you carry your backpack or your briefcase than you do if you're in an open corridor where no one's around? Yeah, you can skip, you can jump, swing your bag around because it's foreseeable that you probably won't cause any injury or harm to anybody. But if you're in a very tight, narrow hallway and there's a crowd of people going, west and east, you have a different degree of care in the speed you walk and the way you dangle your briefcase or your backpack. It's all common sense, but it's up to the jury or the judge in a trial to determine whether you breached that. And we can argue about that. It's a fine line. It's obviously some things are obviously negligent, which sometimes we call gross negligent or wanton behavior. And then there's other times where the person is acting extremely safe. And all of our conduct sometimes falls in between those realms. Just think about my father when I was a kid. We used to have station wagons because our family was, I don't know why we always had station wagons, but we always did. There used to be a tailgate in the back of a station wagon that would lie flat so you could put stuff in the back. When I was a kid, I can remember my father driving with me and like 2 or 3 of my buddies or my sister and brother. We'd sit on the tailgate and let our legs dangle, not on a highway or anything like that, but we'd be going 20 miles an hour, 25 miles an hour, in these country roads, bumping, and we'd be kind of like hoping we'd fall off the back of the thing. And I'm like, geez, if you did that today, someone would be calling DCF and putting you away. And I thought I had a great father. But the point is negligence is contextual. It's depending on how we see in our society what's appropriate, what's not. And many of us can disagree. I don't want to give a name, but some of you have a professor who's a close friend of mine. Believe me, our conceptions of what reasonable and appropriate behavior are very different. He's got to be the most uptight person I've ever met in my life. He changes his socks 4 or 5 times a day. He has different shoes for different, whether he's in a building or whether he's outside. He's very, very cautious about anything he does. I'm surprised he can drink coffee out of a thing with an open lid like that. I think it should be drank out of a very, safe, portal in some ways so he doesn't burn himself. We're different, and we all are. But it's an amalgamation of all of us determining whether or not certain conduct is reasonable or unreasonable. So you got a duty. Of course, the duty has to be breached. The person failed to act reasonably. Then I go a little out of order than the book. The book suggests now there has to be this thing called proximate cause. I'm just going to jump to that as the last. I'm going to flip it around. It has to be damages. So maybe some of you have been like in an accident where you had a little bit of a fender contact with another car. Do you ever get both out of the car? You look at your car, there's no damage. You look at their car, there's no damage. Was there negligence? Yeah, I was looking down at that moment or something like that. But you have to have loss. People sometimes act negligent all the time. I think about the time, I hate to say it, when phones were first starting to get big into texting. I was waiting for someone to contact me, and I was looking down at my phone. I went up on the curb. I caught a curb, actually ruined one of my tires, and I ended up getting 2 new tires because you're not supposed to get just one. I went up on a curb. I slipped my tire, and it ended up being flat later on. I didn't hit anybody. I didn't damage the curb. I only damaged my own property. But was I negligent? Not in the true sense, because there's no damage. There's no loss to a third party, neither property nor person, my own property, because I could sue myself. So you have to have damages. Sometimes, like I think of surgeons, this malpractice, medical malpractice is usually a type of negligence. And there's a famous case here in Massachusetts where a guy was having spinal surgery. Doctor opened up his back, did the repair, whatever that is, a discectomy or something like that, or put in some kind of rods for stabilization of a deteriorating back. And this is a true story. The guy, I believe, had to make it to the bank for a certain hour, the orthopedic surgeon. He left the patient opened up. I don't know if he left a nurse there or whatever, but he said, run down and cash his check or go to the bank and just I'll be right back. Is that a negligent act? You bet it is in terms of conduct. You have a duty of care to your patient. Is it reasonable to leave somebody, basically open and unsutured while you're going to do a little banking? Of course it's also unethical, but it's probably also criminal. It also probably violates certain codes of ethics and standards in the medical field. But is it negligent objectively? Yeah, I think it is. The problem is it wasn't much of a lawsuit because when he came back, he finished the closing up of the sutures, things of that nature, did the sponge count. The person never developed an infection. The surgery was done correctly in terms of the end product result. So if that client came into my office, they'd probably be very excited telling me about this outrageous conduct of the doctor and just going suing us. Well, we can sue anybody. The question is, will it be successful? I'll say, what are your damages? And they say, well, I'm horrified. Well, maybe we can go for some mental damages there, but those cases don't go so great. They're not as easy as they sound. You have to have the intent to cause mental damage. That's a whole other area. So duty, breach of duty, damages, and what's this thing called proximate cause? The but-for one's obvious. You rammed into the back of my car because you were texting, my glasses flew off, they broke, and you damaged my rear bumper, and it's going to cost $500 to fix the bumper. I need $400 for my new glasses. That's easy. It's clear. But for you hitting the back of my car, my bumper wouldn't have been damaged, my glasses wouldn't have broke. That's easy. But the analysis really gets complicated when we call what's called proximate cause. The injury also has to be foreseeable in an objective sort of fashion. So what if you rear end me, and as a result of rear ending, my glasses go off, but I'm upset, and I go to put the glasses back on, and then there's a lot of dust and dirt from where they landed, and I get some dirt in my eye, and it's just bothering me for 2 or 3 days. So I go to the medical provider to check it out, and the medical provider has some unsterilized equipment that they're using to separate my eyelid from my eyeballs and get a better look. I get a serious eye infection. It turns out to be so serious that I lose 100% of vision in my left side of my eye, and I'm going to have my eye removed because it becomes so infected, and I'm going to have a glass eye and a pat, and I don't know, all kinds of things develop. It's almost like those of you like The Simpsons, like I did at one time. I still like them. I don't watch TV anymore so much, but this one negligent act leads to this cataclysmic set of circumstances that no one could imagine other than the most creative individual in the world. You're only responsible for the negligence in which the foreseeable consequences could have occurred. Bizarre consequences are not. One time I had a kid in class, he asked me to throw him a pencil or something back in class. This was when I was a substitute teacher in high school years and years ago. I threw it to him. He missed it. I hit him square in the forehead. It was one of these metal cross pens made out of chrome or something like that. They hit him pretty hard, but he was a pretty funny kid. He grabbed his face and acted like he was, going to die, and he kibbered on the floor for a second. And I was like, oh my God, am I liable for that? Yeah, that was direct. But let's assume I did that. And instead of hitting him in the forehead and hit him, but it somehow cut him on the neck. And as a result on the neck, he had to go get sutures at the hospital. But on his way to the hospital, he gets run over crossing a crosswalk because of a person, ambulance running to go to an accident scene. He gets run over by an ambulance, and now he gets both of his legs completely crushed, and they have to be permanently basically put in the state of atrophy, and he's got to wear braces the rest of his life. Because all I did was throw this kid a big pen or a cross pen, and now I'm responsible for his leg injuries. Well, but for my action, those things never would have happened. But we cut off liability for foreseeable consequences. That's all I'm trying to drive the point at. And also, you have to show that it is the consequence of the act. I think of my father when he was getting ready to croak. He was pretty old. He was in his 80s, and he'd always tease me about being a lawyer. And whenever any issue came up, he goes, too bad I don't know any good lawyers. And he loved doing that. And we were watching a news show about a certain kind of anti-arthritic medication was causing heart disease and causing very serious heart condition, because he was on that arthritic medicine. And he goes, that's why my heart screwed up. And I said, Dad, you're 87 years old. You got heart failure for mesothelioma and many other underlying diseases, not to mention you smoked most of your life, and you still drank right up until the day you died. there's a number of reasons why you might have a heart failure outside of that medication. How can I prove that? I don't know what the name of the medication was. How can I prove the anti-arthritic pain medication is actually the reason why you have your heart failure? That's the proximate cause. Sometimes it's difficult to do. Sometimes there's no connection. Sometimes people have the underlying problem, and that's why sometimes the reason why I got cancer is because I was exposed to these chemicals, or I got cancer because I was exposed to this, or I did that, or I did this. Might be true, but it might not be, and it's sometimes difficult to prove connection. That's part of proximate cause. Not only is it foreseeable, but it is in fact the reason why we have the damages or loss. Business torts, I already went over negligence. Strict liability will be on a test. Strict liability, 2 words. All strict liability means is sometimes, no matter what, we're going to find the defendant responsible because they're strictly liable. One example of that is like a blasting company. They're coming to blast and put a new pool in. I got a lot of a granite yard, for lack of a better word, a lot of ledge, and they're going to have it blasted. No matter how safe they are, no matter how appropriate they behave, sometimes a rock, something will happen, it'll go flying and hit the neighbor's house. Are they liable? Yeah, they're strictly liable, meaning it's no defense to say I wasn't negligent. We hold people, this is the sort of the standard, we hold people and companies that are engaged in inherently dangerous behaviors responsible, even if they were very practical and appropriate in the way they exercise their craft. Another example is the medical field. Say a pharmaceutical company develops a new drug for, let's go back to arthritis. They go to the FDA, they run all kinds of clinical trials on animals first. I don't know if that's what they do, but let's assume that's the protocol to make sure you have a safe drug. You do that first. You test it on volunteers first. You give them all kinds of warnings about potential side effects. FDA is working with you in terms of oversight. You do everything that a reasonable, appropriate, and safe-minded pharmaceutical company would do before they produce a medicine to go out in the public. FDA approves it. You clearly weren't negligent. It's out in the market for 6 months, and we find out people that are using it develop hearing loss, incredible hearing loss after a prolonged use of this drug. Are they liable? Yes. Not under the theory of negligence, but under the theory of strict liability, because anytime you're giving somebody for human consumption for medicines, there's a reasonable expectation that if the drug turns out to be faulty, even though you've done everything you thought was appropriate and science dictated in terms of protocol, you're not going to be held liable. You are going to be held liable no matter what because of strict liability, unless there's a waiver. What was a waiver? You tell the consumers that this may cause hearing loss. A significant number of people have it, but maybe you really want to still take that risk, and the FDA is still allowing approval. Now you're doing what? You're bearing the risk, and that's the only defense they would have is called assumption of the risk because you gave notice. You gave notice to the world that doing this activity could cause these harms, and you still did it anyways. That could avoid potentially strict liability. Strict liability also comes in certain realms where we're just going to hold people liable as a result of society's, public policy provision, because if you're making, and it relates to inherently dangerous products, you could show that you brought in every engineer to make the most safest lawnmower possible, but if the blades are spinning off and cutting people's ankles up pretty bad, you don't have to prove negligence. Clearly an inherently flawed design, it's strict liability. They're going to be liable for any injury that comes out of that negligent design. Negligence is related to strict liability. Strict liability sounds like such a clear, fun, like, oh, I'm glad I got a strict liability case. I don't have to prove negligence. You still have to prove it was an inherently dangerous design or is an inherently dangerous activity, which kind of imbues a certain degree of, kind of a negligent outcome in it. The book is pretty clear on that. Interference with a contract or economic harm. Those of you that like sports, like sometimes a coach or a player will be playing with a team and they're not an unrestricted free agent. They have a contract with the team, but some other team's trying to entice them over. That's usually a violation of law because what you're trying to do is interfere with the contract they currently have with the Yankees or the Celtics or something like that, or the coach, and you need to seek permission. Sometimes you'll hear that, like the Patriots. Patriots often have many good, and I'm not even a Patriots fan, but they often have these stellar assistant coaches, and they're often being recruited potentially to go and work for another team as a head coach. And usually what they'll do is they'll seek permission from the Patriots to speak to them. Why? Because they know they might be subject to a lawsuit for interfering with a valid contract. Now, careful. in order to do that, you have to show malice, that you're really trying to hurt the other party, trying to hurt the patriots and not do a legitimate business practice. Think about if I have a law firm and I've got some good lawyers working for me, some great paralegals, might another law firm try to attract some of the paralegals that I have over at my office or some of the lawyers that are working with me? That's part of normal business practice. But when they're trying to do it in a malignant way or a negative way to undermine my success and to violate a contract that I have. If they're an employee at will, they know they can leave at any time. But what if I had a 5-year contract with an attorney to work for me for certain terms and conditions? You shouldn't be meddling during that period of time because you're interfering with the violation of a contractual right. Related to that is interfering with an expectation of economic gain. It's not an actual contract, but we're expecting certain things to happen, and you're interfering with them in an intentional fashion that is going to cause interference with the example I know of, and I don't think it's in your book anymore, but there's a guy that rented his commercial property to somebody for a certain price for 5 years. He didn't violate the contract, but what he did was he went out and picketed in front of the store, scaring away every customer because he wanted that tenant to move out because he wanted to rent it to a friend or to use it himself. And so he interfered with that economic expectation because no customers would come in there when he was out there with a big sandwich board saying, Louis' Bake Shop sells cockroaches in their lasagna or something. I don't know what he did, but he did something to that effect. That's intentional interference with an economic expectation. You can sue for that. Confusion of product to source. I always thought this was an early chapter, but it's not. It's copyright infringement and or service mark infringement. Think about it. If I make a Mercedes-Benz, I have a symbol that's related to my Mercedes-Benz, and you start making cars and use the identical symbol, what are you really trying to do? You're trying to create confusion of source because you want to piggyback on the goodwill. A Rolex watch, there's a symbol for Rolex watches. You start making watches, you might want to use their symbol or a very close one. Why are you doing it? You're basically committing infringement of a intellectual property right. Got to be very cautious in that area. It happens all the time. Restaurants happen all the time. I was listening to Eddie Murphy the other night doing an interview with Jerry Seinfeld. When I was younger, I thought Eddie Murphy was really huge in the movie industry, and he kind of made a big comeback in his career. But there was one movie he made that was popular when I was younger. It was Coming to America. And those of you might know it and might have watched it. He works at he works at a restaurant called McDougal's. It has golden arches. It sells almost exactly the same menu as McDonald's. And there's an argument, but the guy's name is McDougal. And that's part of the analysis we have to go into. The adoption of the name, symbol, or iconic imagery of what a company is going to use as their mark. Are you stealing it with the intent to confuse the public, to piggyback or dilute their ability to make their mark exclusive to their product or service? And you go through a whole analysis. And if my name was McDougal and I was using that to sell goods, I'd probably be okay. Even McDonald's might be because my name is McDonald's. But however, if you're painting your store the same color, I thought Boston Donuts, I don't know if there's ever a lawsuit, Boston Donuts has the sign with the lettering, the font very similar to McDonald's, but Dunkin' Donuts, in that weird orange brown color kind of a thing. And I pulled into, I'm a coffee junkie, I pulled into a Boston Donut a few times thinking it was going into a Dunkin' Donuts. There's a whole analysis in your book about how you determine whether or not there's been this trademark infringement. Trademark is for goods, service mark is for services. I can think my father, who was a plumber, I was going to be a plumber. My brother was thinking about it too at one time. And to get us into business before we were licensed, he wanted to do a sewer cleaning service because he didn't have to be, according to him, a licensed plumber to do it. And he actually was looking into buying some used vans from a Roto-Rooter franchise down the road. And he said, we'll keep the sign up there. And we'll call us, Corman's Roto-Rooter. And even as a kid, I was just out of high school, I said, I don't know, it doesn't seem like you should be able to do that. And that gut feeling is about a trademark. Because, the symbol, I think it looks like a little tornado going down a sink or a toilet or something like that. That's the mark they made to distinguish their service. It's the same analysis for trademark for a good. Think about my day when I was a kid, and now before all these other modern cars came out, but Cadillac. Cadillac was considered to be like a really well-made product. So, if all of a sudden I'm coming out with, making these, what are these things called now? Vice grips. Well, Vice grips actually is a name too, believe it or not. That is a trademark name. In fact, there's a symbol right on it. It says Vice grip with a little symbol showing it's trademark to let the world know, don't copy that name. But think about it. What if it didn't have a name yet? And I'll call it Cadillac clamps because it fosters that kind of goodwill. And so that's the analysis. It's on page 26, the similarity of the two marks, the similarity of the products, the similarity of the marketing to the types of customers, how much advertising is overlapping with the neighborhood. The favorite one is the actual confusion by the public. If the public's not confused, then there's unlikely to be a service mark or a trademark infringement. Huge area law, intellectual property. Not my cup of tea, but it is important in this chapter. And then business crimes. I'm not going to get into this all. They're all straightforward. I don't know why I call it business crime. Theft is a crime whether it's business or not. RICO is important. I do want to mention that's the Racketeer Influence Corruption Act. Under RICO, it was designed to basically ferret out gangsters who are funneling money into legitimate businesses. But it's gotten much more expansive because you don't have to convict them at proof beyond a reasonable doubt in the criminal realm. They're basically using the criminal conduct in the civil realm to deter businesses from basically hurting the competitive practice because they're able to pump in illegitimate money. So you got two or more people in a criminal enterprise over 10 years, and they're funneling basically those resources and monies and successes in the criminal realm somehow into a legitimate business. You can shut down that legitimate business because it's created through illegitimate means, kind of the fruit of the poisonous tree. Those are the criminal justice majors. Talk about shoplifting, embezzlement, larceny, RICO, and I already mentioned RICO. Computer crimes are kind of interesting, and that relates to licensing and software. That's also intellectual property. Just leave you with a quick story. I know these videos are long. When I was first starting to practice law on my own office, I was doing a lot of real estate transactions, and there's a lot of forms involved. Some of you ever bought a house or going to buy a house, you're going to be filling out a stack of forms that are huge. And as a lawyer, I'm the one that's filling those things out, and my paralegal was doing it too. Back then, we had carbon paper, like triplicate paper, and we said to put that blue stuff in between. Or you could make copies, but the first document had to be correct. And so the numbers were changing because we didn't always close on a date we thought. And so it was always a nightmare. I said, we're not closing this Friday. We're closing next Tuesday. All the numbers are going to change because the interest rate's going to be added on, or the amount of oil left in the house might be reduced. So we're always changing numbers and terms right up to the last minute. It's a lot of work. And I remember talking about that in court, and one of those attorneys, friendly older guy, goes, "Hey, Corman," he says, "Don't you have, I don't know what it's called, easy software closure software?" And that was back when it had big 3x5 floppy disk things you put in the computer. I said, "No, what's that?" He goes, "Oh, it's software. You plug in the information and the numbers will be computed for you by the computer. It saves a ton of time. And then when you want to print out, you're not always printing out and doing whiteout on the typewriter and stuff like that. It'll just print out the documents pristine on the day of closing." I'm like, "Wow, that sounds great." He goes, "Yeah, it costs like $700. I said, "Boy, back then $700 was a lot of money." Just stop by my office. I'll give you the disk. You'll load it up on your computer." Sure. I did. Load up my computer. Didn't think I was doing anything wrong. Well, I'm an attorney. Of course I was. I didn't buy that license. The person that created all that intellectual property and put it on that disk deserves to be paid. That's called licensing. And I believe that person, my friend, the attorney who bought it, probably had a license to him. He wasn't supposed to disseminate to every attorney in Worcester County. But here's where the story gets kind of funny. I get a phone call one day from the company, Easy Stop. Go, "Oh, geez, hi, Attorney Corman. We see you do a lot of real estate transactions." Goes, "We have a great product to save you time." And I said, "Oh, yeah, what's that?" Easy goes, "Well, I have it. I have Easy Stop. It's great. I agree." And they go, "We don't have you on our buyers list." And I'm like, I got a client coming on. I'll call me a little later. Right away, right in that moment, I realized I committed probably a civil wrong, civil copyright infringement. There's also criminal, and that's when you intentionally do it. These bootleg type music CDs, video games, the gaming CDs that people bootleg and have the ability to copy. They're committing theft. It's a type of theft, and it's very important because think about it. If you create something, you want to be able to preserve it, and own it, and pick who gets to have access to it, and you should be compensated. Or you can give it away free if you want, but it should be your decision. And I still feel bad about that. I don't do real estate anymore, so I feel good. Statute of limitations run, so don't call the DA's office. Although I think it would be civil because I didn't have the requisite intent, but it'd still be a civil run. The rest of the stuff in the chapter is pretty straightforward. Criminal, and piracy. Piracy is a big issue. Foreign Corrupt Practices Act coming quite a bit there. Some of you have interest in international trade. You can read that. disbarment, all that stuff. The case problems finally come up first. Some of you can do the case problems in chapter 3 for the first time. You might be saying, what the hell is this case problem looking for? All you're supposed to do, don't look up the case. They are real cases. Just you pretend to be the judge and think of the principle that was in that chapter that you kind of learned and try to apply it to the outcome and drop 3 or 4 sentences why you think this side should win or that side should win or what the principle is. I'll give you pretty much full credit even if you're out to lunch and you're wrong on it, as long as you're doing that analysis in good faith. So try to have fun with it. Video's a bit long. I apologize, but some of you like this stuff. I guess I'm getting some emails from you saying, hey, I think this is great. I mean, if we were in class and we were sitting around together live, I mean, there'd be more of you guys probably interjecting some thoughts and questions. But other than that, it would be going on for over an hour. So maybe be thankful. Don't be afraid to ask questions or raise issues. And many of you raised many issues about the fact that I put chapter 1 and 2 with chapter 3 and 4, but have different submission dates. If you're watching this to the end, you can just submit all 1 through 4 on the later submission date. But if you've already submitted 1 and 2 and have no means to submit 3 and 4, just email it to me and I'll manually go into the grade book and add, the credit that you got it done. So again, don't be afraid to reach out and ask questions. Be well.